California Civil Procedure Handbook rules, selected statutes and cases, and comparative analysis. Chapter 8, Trial and Post-Trial Motions, Subpart B. I think it was right to jury. Trial by jury. 2, jury selection of trial jury panel. The Trial Jury Selection and Management Act in CCP 190 to 237 governs the selection and formation of trial juries for both civil and criminal cases. CCP 192, the jury commissioner for each county must create a master list of persons potentially qualified for jury service. Section 195 to 196. All persons selected for jury service must be selected at random from sources inclusive of a representative cross-section of the area served by the court. Section 197 to 198. Approved sources are a combined list of registered voters and DMV licensed drivers and may also include customer mailing lists, telephone directories, and utility company lists. The jury commissioner must also utilize random selection to create qualified juror lists from the master list and to select jurors for trial jury panels to be sent to courtrooms for voir dire. Section 219. The clerk in each courtroom must randomly select names of jurors for voir dire from these panels unless the jury commissioner provides the court with the trial jury panel list in random order, in which case the court must seat the prospective jurors in the same order as in the list. CCP 222. A party may challenge the entire trial jury panel for failure to include a representative cross-section. CCP 225A. The random selection process make such challenges difficult to establish in civil cases. See, for example, People v. Bro. Criminal defendant must show intentional and systematic exclusion of a particular race, religion, economic class, and other cognizable group. The second subpart in jury selection, 2, jury selection is voir dire in civil jury trials. To select a fair and impartial jury, the trial judge initially examines prospective jurors in civil jury trial. CCP 222.5, Rule 3.1540, Cal Rules of Court. The standards of judicial administration recommended by the Judicial Council set forth the areas of inquiry the trial judge's examination should cover. Standard 3.25. Upon completion of the judge's initial examination, counsel for each party has a right to examine by oral and direct questioning any prospective jurors in order to enable counsel to intelligently exercise both peremptory challenges and challenges for cause. CCP 222.5. The trial judge should permit liberal and probing examination calculated to discover bias or prejudice with regard to the circumstances of a particular case. The fact that a topic was included in the judge's examination should not preclude additional non-duplicative questioning in the same area by counsel. The judge must not impose unreasonable or arbitrary time limits on counsel's voir dire examination. Generally speaking, counsel and when I say I think that means we're going back to the source CCP 222.5 for that rule. Generally speaking, counsel in civil jury trials are given considerable freedom and latitude to directly voir dire prospective jurors unless the particular counsel engages in improper questioning. CCP 222.5. Section 222.5 defines an improper question as any question which, as a dominant purpose, attempts to precondition the proposed jurors to a particular result, indoctrinate the jury, or question the prospective jurors concerning the pleadings or the applicable law. See also Standards of Judicial Administration 3.25F. Okay. 3. Challenges to individual jurors. Challenges for cause. A party may challenge an individual juror for cause for a general disqualification, for an implied bias, or for an actual bias. CCP 225 through 230. Challenges for general disqualification are limited Two grounds: lack of an eligibility qualification to be a competent juror as defined in 228, a challenge for implied bias be taken when a juror possesses some type of relationship to a party or interest in an action which makes a juror inappropriate for that particular case as a matter of law, as specified in 229. By contrast, actual bias is the existence of a state of mind on the part of the juror in reference to the case or to any of the parties which will prevent the juror from acting with entire impartiality and without prejudice to the substantial rights of any party. That's from section 225B1C. How might actual bias be demonstrated during voir dire in a civil case? Actual bias. What again is actual bias? The existence of state of mind on the part of the juror in reference to the case or any of the parties which prevent the juror from acting with entire impartiality and without prejudice to the substantial rights of any party. Yeah. Okay. So the examination questions are going to demonstrate actual bias. Am I going to start? Okay, I'm not going to give example questions. Peremptory challenges. In civil cases, each party is entitled to 6 peremptory challenges from CCP 231C. If there are more than 2 parties, each side is entitled to 8 peremptory challenges, and if more than 2 sides, the court may allot additional challenges. The procedure for exercising peremptory challenges is specified by statute, section 231D and E. Peremptory challenges are taken or passed by the sides, alternatively commencing with the plaintiff. Each party is entitled to have a full panel of jurors before exercising any peremptory challenge. The number of challenges remaining with a side is not diminished by any passing. When each side passes consecutively, the jury selection process is complete, and the jury is then sworn. Next subsection is constitutional limitations on the exercise of peremptory challenges. Traditionally, a peremptory challenge may be exercised for any reason and no explanation is necessary. CCP section 226B. However, recent decisions applying the 14th Amendment to the U.S. Constitution hold that a party to a civil lawsuit may not use peremptory challenges to exclude jurors on account of their race or gender. Edmondson v. Leesville Concrete Co. 500 U.S. 614 of 1991, race-based exclusion in civil action violates equal protection rights of challenged jurors. And then criminal law has its own case. A Braxton violation. Okay? In 2002, the legislature added CCP section 231.5, which provides that a party, quote, may not use a peremptory challenge to remove a prospective juror on the basis of an assumption that the prospective juror is biased merely because of his or her race, color, religion, sex, national origin, sexual orientation, or similar grounds. So that's unique to California. And part 4, putting the case to the jury. Sabella v. Southern Pacific Company, a Supreme Court case of 1969, is demonstrated here to exemplify putting the case to the jury. The decision was given by Justice Mosk. And the case is fairly long, about 10 pages, with like literally 2 straight pages of footnotes, so more like 8. Let's just start it. Defendant appeals from a judgment in favor of plaintiff under the Federal Employers Liability Act. The jury brought in a verdict of $115,500, but by remitter, to which plaintiff consented, the award was reduced to $80,000. Defendant cites as error the trial court's refusal to admit evidence of a disability pension and purported misconduct by plaintiff's counsel. We conclude that the judgment must be affirmed. Plaintiff Mike Sabella was injured while working as a
carman cutter for Defendant Railroad. Among other duties, it was his task to cut damaged freight cars into scrap. While doing so, plaintiff fell from the roof of a car he was cutting and sustained severe back injuries. He alleged that his fall was caused by the negligence of defendant's crane operator in moving the roof section which had been attached to the crane preparatory to lifting the section off, while plaintiff was still walking on it, and by the failure of defendant to provide a reasonably safe place in which to work. The defense was based on a denial of negligence and an allegation of contributory negligence, which may reduce the FELA award. Again, the Federal Employers Liability Act. So we're in the Supreme Court of California arguing federal law. But it's not considered a federal issue. It's not being heard in federal court. Anyhow, at the conclusion of the trial and following the verdict in favor of plaintiff, defendant moved for a new trial on multiple grounds. 1, insufficiency of evidence. 2, excessive damage. 3, disregard by the jury of the court's instructions as to contributory negligence. 4, error in law in excluding evidence of a disability pension received by plaintiff. And 5, misconduct by plaintiff's counsel. The court made an order finding, quote, that the evidence is insufficient to sustain a verdict of the jury, and that there was an error in law occurring at the trial and accepted to by defendant, and such error was prejudicial. The new trial was denied, however, on the condition that plaintiff consent to a reduction of the verdict from $115,500 to $80,000. Plaintiff agreed and does not now challenge the propriety of the reduction. We turn to defendant contention that plaintiff's counsel was guilty of prejudicial misconduct. The alleged misconduct consisted, among other things, of repeat references, both direct and indirect, to defendant as inhuman and heartless, sending plaintiff down the tubes and casting him on the human trash pile as cheapskates, attempting to put up a smokescreen by perjury and deceit so as to deprive plaintiff of his just due and put the money instead in defendant's coffers. Reference was also made to the disparity in wealth between plaintiff and defendant, combined with an appeal to the jurors' personal sympathies. I just want to read footnote 4. In recent years, a number of personal injury lawyers have written books suggesting a variety of somewhat deceptive means of eliciting sympathy for litigants appearing before a jury, and such tactics are not part of the repertoire of an ethical professional man. Alright. Back to the case. It is unnecessary to detail any further the precise language used or to make a phrase-by-phrase comparison between this and other exemplars of misconduct, since it is only the record as a whole and not specific phrases out of context that can reveal the nature and effects of such tactics. Upon review of the entire record, we conclude that plaintiff's counsel was guilty of deplorable misconduct, which might well have been prejudicial. However, in view of the defendant's failure to make proper steps to preserve the latter issue of prejudice on appeal, we find it unnecessary to reach it on the merits. Alright, I'm reading another footnote. In any event, the trial court impliedly found no misconduct, or at least no prejudice, when ruling on the motion for new trial. A trial judge is in a better position than the appellate court to determine whether a verdict resulted wholly or in part from the asserted misconduct of counsel, and its conclusion in the matter will not be disturbed unless, under the circumstances, it is plainly wrong. I haven't heard that plainly wrong standard before, from Cope v. Davison, 1947. Anyhow, let's go to another quote. Generally, a claim of misconduct is entitled to no consideration on appeal unless the record shows a timely and proper objection and a request that the jury be admonished. Horn v. Atchison, T. and S.F. Rye Co. of 1964. Quote, as the effects of misconduct can ordinarily be removed by an instruction to the jury to disregard it, it is generally essential in order that such act be reviewed on appeal that it shall first be called to the attention of the trial court at the time to give the court an opportunity to so act in the premises, if possible, as to correct the error and avoid a mistrial. Where the action of the court is not thus invoked, the alleged misconduct will be considered on appeal if an admonition to the jury would have removed that effect. Quote, verse Davidson, 1947, quote, it is only in extreme cases that the court, when acting promptly and speaking clearly and directly on the subject, cannot, by instructing the jury to disregard such matters, correct the impropriety of the act of counsel and remove any effect his conduct or remarks would otherwise have. From Tingley v. Times, Mere Co., no date. We are aware of no California case wherein the plaintiff's verdict was reversed for misconduct during the counsel's argument and the lack of timely objections, and request that the jury be admonished where such admonition could be effective. Horn v. Atchison, T. and S.F. Ryko again. This case is neither precisely like Horn Supra, in which no objection or request for admonition was made until after conclusion of the closing argument and relief was thus denied, nor like Hoffman v. Brandt of 1966, in which an admonition, especially as they're given by the trial court, could not have been effective under the circumstances, nor like Love v. Wolf, in which 1964, in which admonition of the jury was requested several times but disregarded by the trial court. Here, defendant remained silent as to all but one line of argument, and as to the latter he objected but failed at any time to request an admonition of the jury to disregard the remarks. Under the circumstances, we conclude the defendant must be denied relief. The record indicates that while plaintiff counsel accused witnesses of perjury, made reference to defendant's wealth and plaintiff's lack of resources, and appealed, though indirectly, to the jurors to place themselves in plaintiff's position, all of which tactics are improper and to be condemned. See Hoffman v. Brandt, Horn v. Atchison, Love v. Wolf. Defendant did not once object to such remarks, much less request an admonition of the jury. In the absence of, quote, in the absence of a timely objection, the offended party is deemed to have waived the claim of error through his participation in the atmosphere which produced the claim of prejudice. Citing Horn. Defendant did object, however, to one distinct line of argument by his adversary. As discussed earlier, defendant challenged references to turning his back on plaintiff and refusing to help him or to give him a job, and generally being out to defeat his claim. This was, in fact, perhaps the mildest and least prejudicial of all alleged instances of misconduct. Although counsel used improper language, the question of defendant's treatment of plaintiff appears to have been put in issue, at least in part, by defendant when it asserted during opening statement that there was work plaintiff could do on the railroad. However, even assuming that the entire line of argument was misconduct, defendant remained silent when, during opening argument, plaintiff's counsel at least twice alluded to defendant's denial of a job and of hospitalization to plaintiff, and when during trial he used such terms as cheapskates in referring to defendant. It was not until closing argument, after defendant had attempted to counter the unfairness argument with evidence of plaintiff's disability pension rather than by means of long-established procedure of admonishing the jury. I gotta read this footnote. Defendant asserts that did not know at the outset how heavily this line of argument could be emphasized, although during one objection defendant claimed that it had been anticipating such an argument and meant to counter it by evidence of the disability pension. Obviously, the fact that this counter evidence was subsequently excluded could not alone excuse the failure to object if, in fact, the argument was improper. It was not the exclusion of the pension evidence that determined the propriety of the language and allusions employed by plaintiff counsel. The defendant finally objected, but even at the tardy point, counsel did not request an admonition. Certainly, as the particular line of argument, admonition would have been effective, especially if requested at the outset. One of the primary purposes of admonition at the beginning of an improper course of argument is to avoid repetition of the remarks and thus obviate the necessity of a new trial. From Horn, except perhaps in cases of highly emotional or inflammatory language or reference to extremely prejudicial circumstances not in the evidence, a jury must be deemed capable, if so instructed, of ignoring references to the litigant's personal or corporate virtues and confining itself to the merits of the case. Defendant was apparently not aware of the tactical availability and desirability of an admonition to the jury. When plaintiff attempted to argue damages on a per diem basis, defendant objected strenuously and asked for and received an admonition that the jury disregard this line of argument. As to propriety of that ruling, see Beagle v. Vassold, 1966. It is significant that far more questionable statements made at the same time, which defendant now cites as misconduct, were not alluded to in the per diem objection. Defendant urges us to ignore the rules of procedure relating to the magic words of proper objection and admonition, but the procedure outlined above is not a meaningless ritual. It has been designed through judicial experience to prevent, by timely words of caution, the very problem with which we are here concerned. We emphasize again that the particular language used by counsel and the form or lack of objection by defendant in this case are not meant to serve as invariable guidelines for future reference. Each case must ultimately rest upon the court's view of the overall record, taking into account such factors inter alia as the nature and seriousness of the remarks and misconduct, the general atmosphere, including the judge's control of the trial, the likelihood of prejudicing the jury, and the efficacy of objection or admonition under all the circumstances. Our conclusion should in no way be interpreted as condoning the deplorable conduct of plaintiff's counsel. So we get to footnote 9 with that. Alright. Anyhow, not important. However, punishment of counsel to the detriment of his client is not the function of the court. Intemperate and unprofessional conduct by counsel, as is here involved, runs a grave and unjustifiable risk of sacrificing an otherwise sound case for recovery, and as such is a disservice to the litigant. These same tactics in another context would likely result in a reversal. However, under the facts and circumstances of this case, we conclude that the award to the plaintiff, as modified by the arbitrator, is justified. The judgment is affirmed. And then we have Chief Justice Traynor dissenting, and he gives a pretty lengthy footnote between interchange between the judge and the attorneys. So clearly Traynor believed that he would reverse the judgment on the ground that the misconduct of counsel for plaintiff deprived defendant of his right to a fair trial. You know, like notwithstanding the fact that defendant didn't object or ask to admonish the jury. So he gives all those examples, but he's reaching this effect by sidestepping the need for defendant to object. So I suppose I'll read it. But after this case, we have notes and questions. So actually, I'm going to read the notes and questions first. This is getting lengthy, and then I'll read the dissent. Closing argument. Upon conclusion of the evidence at trial, the attorneys have the right to present closing arguments to the jury. CCP Section 6077, as Sabella indicates, vigorous and forceful argument is not only expected but is proper and desirable. An attorney has the right to express opinions based upon fair deductions and reasonable inferences from the evidence given at trial. So those are the magic words. Highlight them. It's fair deductions and reasonable inferences, not just like personal views and like exaggerations from the evidence given at trial. Okay, the argument need not be absolutely logical, but must be based in facts evidence. The difference between proper and improper argument is difficult to find. Misstatements of the law or facts during argument are clearly improper, but beyond the line is less clear. This general standards such as prohibition on appeals to prejudice, passions, or sympathy of the jury provide minimal guidance at best. An attorney has an ethical obligation to represent the interests of his or her client zealously within the bounds of the law. See ABA Model Rules of Professional Conduct, Comment to Rule 1.3 of the California Rules of Professional Conduct provide that attorneys shall not intentionally, recklessly, or repeatedly fail to perform legal services with competence. Rule 3-110 California Rules of Professional Conduct. Competence is a legal service in any legal service means to apply the diligence, learning, and skill and mental, emotional, and physical ability reasonably necessary for the performance of such service. Other rules require an attorney in presenting a matter to a tribunal to employ such means as are only consistent with the truth and not mislead the judge or jury by an artifice or false statement of fact or law. Did the attorney for the plaintiff, Isabella, breach these rules? Did the attorney for the defendant, if both attorneys and Isabella breached ethical duties, whose conduct was less professional? I mean, they both did, because the one had an obligation to object, but the other put him in that position, potentially. But you don't know how much, it's going to progress throughout the life of the case. And maybe that's what the dissent opinion is about. It's probably about, like, look, we didn't initially think it was going to keep surmounting to a level that would impact the outcome of the case. So, where was I? Jury instructions. This is section 2, or this is the second note. A party is entitled to, upon request, to correct non-argumentative jury instructions as the law on every theory of the case which is supported by substantial evidence, whether or not that evidence is considered persuasive by the trial court. Saul versus General Motors. The refusal to give a jury instruction adequately covering a party's theory where the theory is supported by substantial evidence may be considered prejudicial error. Jury instructions must accurately and completely state the applicable legal principles and must not be slanted, unduly repetitious, or argumentative. The pattern jury instructions adopted by the Judicial Council and set forth in California Civil Jury Instructions, CCP, are the official approved instructions of California. See Rule 2.1050E. California Rules of Court. When KC does not contain an instruction on a point, the judge may modify a KC instruction to submit the issue properly or use a special instruction submitted by a party, but the instruction given should be simple, brief, partial, free of argument, and accurate. Generally speaking, counsel for the respective parties must deliver proposed jury instructions to the trial judge and serve them upon opposing counsel before the first witness is sworn, CCP 607A. Therefore, before commencing of closing arguments, counsel may deliver additional proposed instructions upon questions of law developed by the evidence and not disclosed by the pleadings. Before commencement of the closing arguments, the court, upon request, must determine whether to give, refuse, or modify the proposed instructions, must decide to what additional instructions will be given, and must advise counsel of all instructions to be given. 607, 609. Upon the jury retiring for deliberation, the trial court may, and if requested by the jury, shall supply the jury with a written copy of the instructions. 612.5. 3. Comments by trial judge. A trial court judge has the authority to call and interrogate witnesses. Evidence Code Section 775, and to comment on the testimony and credibility of any witness. California Constitution, Article 6, Section 10. However, a judge's power to comment on the evidence is not unlimited. A judge cannot withdraw material evidence from the jury or distort the testimony, and must inform the jurors that they are the exclusive judges of all questions of fact and of the credibility of witnesses. Lewis v. Bill Robertson and Sons, 1984. At the end of the notes regarding putting the case to the jury, I'm going to go back to the dissent if you want to fast forward. Chief Justice Traynor said, going into the dissent, said that in plaintiff attorney's opening statement, counsel for the plaintiff made a preliminary appeal to the sympathy of jury by stressing the plaintiff had left school after 7th grade to go to work and had worked for the defendant for 36 years thereafter. In the course of the trial, counsel deliberately sought to implant prejudice in the jury against defendant. He insinuated, without offering any evidence to prove it, that defense counsel had withheld photographs favorable to plaintiff. He referred to defendant and its attorneys as cheapskates. He asked rhetorical questions calculated to convey the impression that defense witnesses were not honest in their testimony. Nor was that all. After several days of trial, when the trial court is normally reluctant to grant a mistrial, he used his closing argument to intensify his appeal to the passion and prejudice of the jury. The appeal was the more insidious because it followed upon a fulsome declaration of his great trust in the jury system. His trust was such that he urged a verdict on issues extraneous to the merits. Approximately a third of his argument consisted of emotional attacks on the defendant, its counsel, and the witnesses for the defendant. He called upon the jury to tell the Southern Pacific that the verdict was a high time to quit treating their employees that way. There was no question that his conduct was on its face prejudicial. The questions to be resolved is whether or not defendant waived its right to complain, even though it repeatedly made objections at the trial. The objections were more than enough to alert the trial court. The court itself sought to call a halt to the objectionable conduct by admonishing counsel for plaintiff to confine yourself to the evidence and such reasonable implications as you may draw therefrom. When counsel for plaintiff nevertheless made fresh appeals to the passion and prejudice of the jury, the defense counsel continued to object. The court once again admonished counsel for plaintiff to stay within the confines. The counsel for plaintiff persisted in his conduct in the face not only of defendant's objections and motions for mistrial, but also of the admonitions of the court. He evinced and studied determination to ride roughshod over any and all objections or admonitions. Though he threw one caution after another to the wind, he now contends that the defendant waived objection to any misconduct by not supplementing his repeated objections with a request that the trial court admonish the jury to disregard the misconduct. No admonition, however, could cure the prejudicial effect of such misconduct as prevailed throughout this case. Accordingly, defendant's failure to request admonitions to the jury does not preclude it from challenging the misconduct on appeal. Hoffman versus Brandt, Horn versus Atchison, Love versus Wolf. Plaintiff's counsel can hardly claim that his repeated appeals to passion and prejudice were of such little appeal that they could have been simply erased by admonitions. Counsel for plaintiff offers a brace of alternative contentions, namely that there is no misconduct but only colorful argument, and that in the event of any error it was cured by the trial court's mature. These contentions cannot be sustained. It is misconduct to compare the wealth of plaintiff and defendant. Counsel for plaintiff did so. It is, let me read this. No, he doesn't cite any law. He just is giving transcript from the case. It is misconduct to accuse defendant and defendant's counsel of suborning the perjury. Counsel for plaintiff did so. It is misconduct to accuse defense counsel of withholding evidence. Counsel for plaintiff did so. It is misconduct to suggest to jurors that they measure damages by what they would take to endure plaintiff's suffering. Really? Alright, I'm just going to highlight all these misconducts. You can't compare wealth. You can't accuse anyone of suborning perjury or accuse them of withholding evidence. Suggest to the jurors they measure damages but what they would take to endure plaintiff's suffering. Counsel for plaintiff did so. It is misconduct to suggest facts not in the evidence that counsel knows would be contradicted by evidence that the court had excluded. Counsel for plaintiff did so. In the line of argument that the defendant refused to give plaintiff a job is contradicted by the fact that plaintiff did not attempt to return to work but applied for pension instead. We may assume without deciding that evidence of the pension was inadmissible. The courtroom is a forum for the presentation of evidence and rational argument, not a stage for over melodrama. The responsibility of lawyers to raise issues, not scenes, and to reason about them, not non-theatrical terms. Invective, with all its theatrics, has no place in the language of law. When appeals to passion and prejudice may have influenced a verdict, they may have influenced on the issue of liability as well as on the issue of damages. Hence, in such a case where mature cannot cure the error. There is no cure but reversal for the error that impairs the right to a fair trial. The right to fair trial includes the right to an impartial trier of fact and the correlative right to a trial free of appeals to passion and prejudice. We take great care to excuse prospective jurors who may be subject to emotional appeals. We take great care to instruct jurors not to discuss the case with outsiders or to read about it so that they will remain beyond the reach of influence outside the courtroom. It is a minimum propriety to guard against calculated attempts to prejudice the jury inside the courtroom, for they do violence to the substantial rights of a litigant. Still worse, they would, in the long run, so debase the judicial process that no one could enter a courtroom confident of a fair trial.